Good evening, everyone. Welcome to our Wednesday, May 4th, North Middlesex Council meeting. Call this meeting to order. Roll call. We are still expecting Councillor Keogh and Councillor Hemming. Disclosure of pecuniary interest, if anyone has one. Please forward them to our clerk. We will start our meeting with the quarter revision, but just before we start, I wanted to make note of some graduates of Sacred Heart Elementary School. 3 young men who went to Sacred Heart, I understand, right from kindergarten together, and they played hockey together right through and played for the Elgin Middlesex Chiefs, I believe, this last couple of years. And all 3 of them were drafted by the OHL. These boys grew up together and they were all drafted, and it's Dylan Richter, and he was drafted by North Bay. Renee Van Bummel was drafted by the Knights, and Ethan Ficina was drafted by Hamilton. And so I wish all of them well and congratulate Sacred Heart on their students, former students. And if anyone has any interesting events and accomplishments that are by our youth in North Middlesex, please forward them to me. I'm more than happy to make note of it. And congratulations to all 3. And Alice is a very happy grandmother. She's the one who let me know. All right, at this time, we will enter quarter revision, and it is 5:45, and this is for the Vandal Mcewen Municipal Drain. The appointment of the members is the Deputy Mayor, Cornelison, Councillor Moyer, and myself. So at this time, Joanne, if you'd like to start.
Mayor and members of council, in front of you is the report for the quarter revision for the Vandal Mcewen drain. Staff did receive a verbal inquiry, but there was no written inquiries received. And I also want to point out in the report that I didn't break out the non-ag and the ag properties. That report has been amended for filing purposes, and this in no way affects the assessments of the engineer's report. So my recommendation is that the quarter revision confirm the assessment schedules as detailed in the Dietrich Engineering Limited report dated March 7th, 2022, and that a motion be passed to accept the assessments.
Questions from the committee? From the quarter revisions? Any questions? Deputy Mayor Cornelison.
Joan, I know I asked you last time on another similar situation, but once again, it seems that the municipality shared these streets. It's fairly substantial. Is that again for road crossings?
It is. This one, there's an open cut, plus there's a bore in 2 different spots in the McGuire Road.
Okay, all right,
Yeah,
thank
and then
you.
there's new catch basins put in as well.
I'm sorry?
There's new catch basins and culverts put in as well.
Okay, thank you.
Any other questions? We have a recommendation in front of you. What's your wish? Moved by Councillor Moyer, seconded by Deputy Mayor Cornelison. In favor? Carried. Thank you. Thanks, Joanne. We do it this time. We have to go into. We have to go into. We have to adjourn. Sorry, adjourn the quarter revision. Deputy Mayor Cornelison, Councillor Moyer, all in favor? Carried. We're going into our regular meeting. We have our minutes of our meeting from April the 20th and the quarter revision minutes from April 20th as well. Any business arising or errors or omissions? Seeing none, we need a mover for the minutes. Councillor Moyer, seconded by Councillor Keogh. All in favor? Carried. Thank you. We are a little bit early, I think, to start our planning. So we do have, if you go to department reports, 7.1 is a report from the planner, and that's a 2021 planning summary. And Stephanie, if you'd like to.
Thank you. Well, I just gotta check my Zoom. Good. So the report council has before them is addressing a 2021 planning summary. I would say overall, it continues to be it was a busy year for the planning side of things. Overall, we had about 10 more applications than we did in the year 2020. And of course, remain busy in an increase in residential growth and development in general, in my opinion. We continue to see various inquiries for both residential infill lots and plans of subdivision, site plans, etc., for additional residential growth. So I think that was the the area of focus for 2021. And I'm here for any questions if you have any. Thank you.
Sorry, questions for Stephanie on this report? You all have that report in front of you, I believe, in your agenda? Pardon me? No, this is strictly for council.
I have a question.
Strictly for council. Go ahead, Deputy Mayor.
Stephanie, I know you make reference to temporary use and granny flats in your report. Is there a difference between the two?
Sorry, temporary use is the application type to permit a granny flat.
Okay. And the temporary use is for a period of 3 years?
That is correct, yes.
Is there any indication that that may be extended for a longer period of time?
So through the mayor to the councillor, under our current official plan policy direction, the maximum permitted for any temporary use application, whether that be a granny flat or other temporary use, is 3 years. Granny flats in particular in the Planning Act, it is actually permitted for a period of 20 years, but that would require a policy change in our official plan to allow that for a longer period of time. But you are correct. There is the ability to apply for renewal for any temporary application.
And does the same apply to agricultural buildings to house migrant workers?
That is correct. So our current zoning bylaw permits a second residential house through a temporary use application specifically tied to farm workers.
And that's a 3-year period or?
Correct.
Yeah,
Yes.
thank you.
Other questions? Seeing no other questions, I would have just on this, on your comments, Deputy Mayor, maybe staff could look at that policy of whether we should change that policy to increase the length of it from 3 years.
I believe that the county is looking at its plan amendments or zoning or planning as well. And it may be, we may want to wait for that.
Right, but I mean, it's just to look at length of that. Okay. No other questions? All right, we need a motion to receive the report. Councillor McClinchy, seconded by Councillor Nickel. All in favor? Carried. Thank you. At this time, I think we'll need a word 5-2. We should go, right?
My preference would be to wait till.
To wait? All right, maybe we can stay with staff report then. From the clerk, your multi-year accessibility plan, if you could do that report.
Thank you to the mayor and members of council. A report has been prepared for you, which is a combination of a joint multi-year accessibility plan for the year 2020 to 2027, as well as an annual status report. The summary of the report is under the Accessibility for Ontario's Disabilities Act. The County of Middlesex and its local municipal partners create a joint multi-year accessible plan, which builds on accomplishments of the previous plan, as well as it ensures that compliance with the requirements under AODA and the integrated accessibility standards regulations are met. The purpose of the plan is that it acts as a roadmap detailing key initiatives and progress made, as well as goals and timelines to be achieved over the next 5 years. It demonstrates the commitment made into identifying, removing, and preventing barriers for people with disabilities, and it's designed to create a more accessible, inclusive community. The County of Middlesex has already approved these documents on April 5th and are looking for endorsement from the lower tier municipalities. Prior to this going to County Council, each lower tier municipality and staff are quite involved in developing this plan. And the recommendation before you is that council accept and endorse the 2022-2027 multi-year accessibility plan and the status report as provided through the County of Middlesex, and that the documents be posted on the municipal website.
Questions for the clerk? No questions? We have a recommendation in front of us. Looking for a mover. Councillor Nickel, seconded by Councillor Hemming. All in favor? Carried. Thank you. We still will go to, I think, your next report then, if you will, about the Epenezer Cemetery.
Thank you to the mayor and members of council. A report has been prepared for you, which is entitled Update to Epenezer Cemetery. As council may or may not recall, it's been a while. Back in 2012, there was a report through our cemetery board that came to the municipality regarding the request to take over ownership and to look after the trust funds for Ebenezer Cemetery. At that time, Ebenezer Cemetery was going to look after their own operations. But since 2012, extensive communication has occurred between the board, the ministry, and the municipality on available options that now are being contemplated. A number of issues have arose over the years, which delayed the transfer of ownership and the management of the cemetery. Additionally, during this time, the board formally resolved so therefore the previous thought of them maintaining the operations is no longer viable. Wes Hodgson has been the active member communicating with the municipality over this ownership takeover. And we recently met in March with staff to get an update on where we were at. And so that has been outlined in the report for council's consideration. At this point, the recommendation is that the report entitled Update Ebenezer Cemetery be received, and that staff be directed to continue working with legal to assume Ebenezer Cemetery, and that staff make arrangements to commence grass cutting and or maintenance at the cemetery effective 2022.
Questions from council? Councilor Nicol.
Yes, I just have one question. If our staff takes over the cutting and taking care of the property, what is the liability if someone gets hurt or something gets damaged when it is not yet in our name?
So currently we have cemeteries where we have contractors come in and do grass cutting. It's a liability of, I guess on the flip side, that if it doesn't get done, there would be complaints received. I think it's probably a relatively low risk exercise to do the maintenance, and we do anticipate the transfer occurring probably within the next few weeks. So it would be a short term, probably before they even get out there.
So I understand if it's a short term. I am concerned, having been out to that cemetery, there's a lot of very, very old tombstones out there. And I would be very concerned that if staff hit it with a lawnmower or broke it accidentally, that we would be liable.
I'm going to say that I think our staff would be very conscientious of when they're cutting around stones and the fragility of a lot of the older stones out there, and every effort is made to minimize contact with it. So by using weed eaters instead of going up with mowers, our facilities manager is here and could speak to it further, but I don't think it's been identified that there's been concerns expressed over that.
Okay, Councilor McClinchy and then Councilor Hammond.
Just to clarify things, I recall them coming to council wanting the municipality to take over that. So they had a ground radar thing to find out where bodies, did they not? St. Brins?
No, you're thinking of Brinsley Cemetery. This is Ebenezer
It's on McGuire Road.
on McGuire.
On
Okay,
the
so
wire road.
I think they were paying about $800, $1,200 for grass cutting. Maybe I'm mixing that up with the other one.
I can't comment to the cost on the grass cutting. We've never done the Ebenezer grass cutting previous.
Oh, sorry, then I'm thinking of
Brinsley.
Brinsley. Okay, sorry. Okay, thanks.
Okay. Councilor Hemming?
So in taking that on, we assume all costs incurred on that. Is there any funds from the cemetery board or whatever that we can apply towards the cost?
So there are funds, but they're actually trust funds, and the only money that is available to cemeteries is the interest earned off of trust funds. So that is a legislated account that Ebenezer Cemetery had. So they would be transferring that from one trust account into a trust account under the municipality's care and control. But again, unfortunately, the way it's legislated through the bereavement authority, is that we are only entitled to use interest. Now, the other thing that Mr. Hodgson did say, I guess the cemetery has been quite active with their decoration days and generate revenue that way that would be coming to the municipality in the future if they continue to hold decoration day. But other than that, there's really no revenue source, unfortunately.
Okay, thank you.
So, Councillor Nicol.
I just have one more question. If it's a closed cemetery, I noticed in your report about interment. Can you explain that to me if it's a closed cemetery, how that's allowed, if it's from history or?
In my report, it references it to be a closed cemetery.
It didn't reference it to be a closed cemetery, but I understood that it was.
So what would there would be no plot sales. The only thing that could occur potentially is interments. But again, that is at the sole discretion of the municipality when that ownership is taken over. If we are able to properly undertake that interment, and there's a lot of operational things that are looked at. By the sounds of it, I think it's be very minimal what the expectation would be for interments there.
Just a
Councillor
question.
McClinchy, then Councillor Duke.
I'm sorry.
Go ahead.
If the municipality takes over this Ebenezer Cemetery, would we be responsible then for fixing the tombstones and foundations and where would that money come from?
So municipalities really don't have an opportunity or have a much say in not taking them over when there is situations like this. Somebody has to assume the ownership or assume the cemeteries. Practice has been that the monuments belong to the interment rights holders. In predominantly in 2012, there was substantial changes to the act. And from that time on, any maintenance work to stones, our first were to try to seek out and find the owners of the stones. On old stones, that's virtually impossible. So our obligation for liability is if a stone is in a manner that is not safe, that our obligation would be to perhaps lay it down in that manner so it doesn't hinder the public safety at the cemetery. But you're quite correct, fixing stones and that there's just no money to do that. And again, the stones are the responsibility of the interment rights holders.
Okay. Councillor Keel.
Thank you, Mayor Rob. My first question was answered. My second question is, in the event we do take this cemetery over, we are still able to accept donations from family members to contribute for the upcare and whatnot?
Absolutely. And in fact, we encourage it of any cemetery that we are always open to donations.
Thank you.
Any other questions? I think as you alluded to, Jackie, that we really don't have much choice but to take these on. I mean, this one has been a long time coming because there was some issues with it. But it started, as you say, 10 years ago that Wes came here. So, yeah. Any other questions on this? We have a recommendation in front of us. Moved by Councillor Moyer, seconded by Councillor Keogh. In favor? Carried. Thank you very much. At this time, I would ask for a motion to adjourn the regular meeting and the regular meeting adjourn and proceed into public meetings, including Committee of Adjustment. Councillor McClinchy, Councillor Hemming, all in favor? Carried. Thank you. So our first item is notice of public meeting to consider application B8 2022 ZBA 7-2022 located at 35622 Hutchison Road. And the owner is J&D McClinchy Farms. Is there someone here from there? If you'd like to come up, here at the center table, you get to be front row center. Welcome. And so Stephanie, sorry, if you'd like to start.
Thank you. I'm just going to share my screen. So there will be a map before us. All right, so the purpose and effect of the application is to sever a surplus farm residence with a lot with a frontage of approximately 45 meters along Hutchison Road with an area of approximately 0.55 hectares or approximately 1.35 acres from a farm parcel with a total area of approximately 75 acres. The lands proposed to be severed contains a single detached dwelling, 2 accessory buildings, and are serviced by a municipal water connection and a private septic system. The lands to be retained contains agricultural land and crop production and are vacant of any buildings and structures and are unserviced. As part of the conditions of the consent application, an existing access will need to be demonstrated to be existing, or a new entrance will be established for the lands to be severed. A concurrent zoning bylaw amendment application has been filed in order to rezone the severed lands to the agricultural small holding zone, that's the AG1 zone, in order to recognize the residential use of the lands and limit the permitted uses. The rezoning application also seeks to rezone the retained land from the general agricultural zone to the general agricultural exception zone. And that's in order to prohibit residential use as required by the North Middlesex official plan. The provincial policy statement, the county official plan, and the North Middlesex official plan generally permit lot creation in agricultural areas to dispose of a dwelling surplus to a farming operation as a result of farm consolidation, subject to evaluation criteria. Staff are satisfied that farm consolidation will be achieved and that the residents may be deemed surplus to the needs of the farming operation as a result of farm consolidation. The applicants have provided supplementary information that demonstrates ownership of a number of farm holdings containing at least 1 additional dwelling, and impact data has indicated that the existing dwelling was constructed approximately in 1947. The North Middlesex official plan indicates that the severed parcel should generally only be as large as necessary to accommodate the dwelling and the services, and have a maximum lot area of 1 hectare or 2.5 acres in size. Staff note that the proposed area of 0.55 hectares or 1.35 acres remains consistent with the maximum size within the North Middlesex official plan. And staff are of the opinion that the lot is an appropriate size to contain the dwelling and the services, and that minimal agricultural land will be removed from production. In reviewing the application in further detail, staff did identify that the lands to be severed have a frontage of 45 meters, whereas the AG1 zone requires a minimum frontage of 50 meters. And additionally, an existing shed has a height of 7 meters, whereas the maximum height for accessory structures is 5.5. And as such, staff recommend that the lands be rezoned to a site-specific agricultural small holding zone in order to recognize those deficiencies. And all other zoning standards of the AG1 zone are appearing to be met. And in regards to the lands to be retained, staff recommends that a site-specific zoning, as part of the already applied for site-specific zoning, recognize the undersized agricultural parcel of 29.8 hectares or 73.65 acres, whereas the minimum permitted is 39 hectares. And all other criteria of the A1 zone appears to be met. Notice of the application has been circulated in accordance to the requirements of the Planning Act, and staff received the following comments. North Middlesex Chief Building Official noted the following: please provide confirmation from a qualified individual that the sewage system servicing the severed house will be wholly contained on that property. Provide confirmation that the water line and hydro service will not encroach over the retained farmland. That the applicant obtains a change of use permit for the retained farm building to confirm it is structurally adequate and to be used as a residential accessory building, and that is no longer suitable for housing livestock. Asabo Bayfield Conservation Authority noted that from the information submitted, it appears the regulated area is not being fragmented and will be contained to the retained parcel of the subject lands, which is, you can see on your screen in front of you, the red hatched area that they are referring to. As such, ABCA does not have any natural hazard or natural heritage concerns with the proposal. The North Middlesex Public Works Department did note that there is an existing water line in front of Hutchinson Road, and any new connections would be subject to dues and levies at the expense of the owner at the time of connection. The existing dwelling does have access off of Hutchinson Road, and a drainage reassessment will be required as a condition of the application for the Hutchinson Eagleson drain due to the severance. And at the time of writing the subject report, no written comments, have been received by the public. So it is recommended that the application for consent be granted subject to conditions, and that the zoning bylaw amendment application be approved in principle, limited to first and second reading only, until such a time that the plan has been registered. Thank you.
Thank you, Stephanie. Applicants have anything you'd like to add? Nothing? You're good with that? We have no written submissions, you said? Is there anyone in the public that has any comments on this application? Seeing none, I would ask council, do you have questions? Any questions from council on this? No questions? We have a recommendation in front of us. What's your wish? Moved by Councillor Moyer, seconded by Councillor Nickel. All in favor? Carried. Thank you. Thank you. Jackie, go ahead.
I just wanted to make the comment that with all planning applications this evening, if anybody requests a copy of the decision, of any decisions made this evening, they should make a written request to the clerk's office. And as with any decisions made this evening, there is a 20-day appeal period that applies from the date of notice of decision, and that is all put out on your notice of decision. And again, I just want to reiterate, this applies to all planning applications being heard this evening.
Thank you. Thank you. Our next planning application is notice of public meeting to consider application B9-2022 located at 175 Broadway Street. And Adele Minu, is it Minu? Is that right? No, Minot? Okay. Okay. Okay, Stephanie?
All right, there we go. So the purpose and effect of this application is to sever a parcel of land for lot addition purposes to be merged with 175 Broadway Street for the purposes of constructing a detached garage. And it is highlighted, the section that is proposed to be severed and merged is highlighted in green on the screen in front of you. The subject lands are located on the south side of Broadway Street between Park Hill Main and Ann Street within the urban settlement area of Park Hill, and are 883.05 meters squared in size. The applicants are proposing to sever a parcel of land for lot addition purposes that has an area of approximately 135 square meters to be merged, as mentioned, with the abutting property. The abutting lot would increase in area from approximately 623 square meters to approximately 758 square meters in size, and currently contains a single detached dwelling and a shed. The applicant advised that the intent of obtaining the additional lands is to have room to accommodate the construction of a garage. The lands are serviced by a municipal water connection as well as a municipal sanitary connection and have existing access off of Broadway Street. And the lands proposed to be retained, which is highlighted in yellow on the screen in front of you, would be approximately 747 square meters in size and contains an existing detached garage and landscaped open space. The applicant owns both abutting properties in separate ownership, being 175 Broadway and the subject lands directly abutting to the east. The two parcels currently function as one residential lot. However, the applicant advised that they wish to eventually sell the existing lot between 175 Broadway, and as such will require additional lot area to construct a garage on their property to replace the one that is currently being utilized on the abutting lands. The applicants have advised that the standalone garage will not be in compliance with the zoning bylaw as a result of the proposed lot addition. And staff has recommended as a condition of the application that the garage either be removed or that a minor variance application be applied for to permit the side yard setback deficiency until such a time that the lot addition has been completed, the new garage constructed, and the existing garage eventually demolished. The North Middlesex official plan permits lot additions so long as they are considered minor in nature. Staff are of the opinion that the lot addition does not offend the residential land use designation policies and is considered to be minor in nature as it is not anticipated to alter the residential use of the lands, and it'll actually result in two abutting properties that are more similar in size. Staff have reviewed both the lands receiving the lot addition as well as the lands to be retained and are of the opinion that the minimum lot area and lot frontage standards of the R1 zone will be maintained. The applicant has provided a concept plan for 175 Broadway Street, which demonstrates that the lot addition will result in adequate space to accommodate a new garage that meets the minimum lot stack requirements of 1.5 meters or 5 feet. As previously mentioned, the standalone garage on the lands to be retained will be located too close to the lot line at approximately 0.58 meters, and as a result of the lot addition, and will ultimately need to be removed in order to maintain zoning compliance. And all other standards of the R1 zone appear to be met. Notice of the application has been circulated to agencies as well as property owners in accordance to the requirements of the Planning Act, and staff received the following comments. Asable Bayfield Conservation Authority had no concerns with the proposal. Enbridge Gas did note that there may be service lines running within the area, which may or may not affect the proposed severance. The North Middlesex Chief Building Official offered no objection, but did note that the existing garage on the retained parcel should be confirmed to meet the zoning bylaws required setbacks. The North Middlesex Public Works Department had no comments, and at the time of writing the subject report, no comments were received from the public for the proposal. So it is recommended that the application be granted, subject to the conditions which council will have before them. Thank you.
Thank you, Stephanie. The applicant, anything you'd like to add? Yes, go ahead. Would you turn on your microphone, please?
Okay, I
Thank
just
you.
assume I'm loud. So I just want to make sure that I'll be able to build the new garage without the certificate of completion. I'm just concerned I'm going to put myself in a position where I have to take down the existing garage before I can build the new garage, and then my husband will leave. Well, not right away, but so I just want to be sure that as part of it, that when I apply for the building permit, will I need the certificate of completion?
Who wants to answer that? Stephanie, go ahead.
Through the mayor, that is correct. In order to build the new garage, you will need to have completed the severance application to have the new parcel of land completed and fully merged with yours in order to be able to build wholly contained on your property. However, I did provide flexibility in the condition, so you will not be required to tear down the garage prior to the consent application being completed and the new construction being dealt with, but you will be required to apply for a minor variance application to address that deficiency until such a time that you're in a position to remove that structure.
Okay, so for the minor variance, I didn't know they came in time allotted. Like, I thought either you just applied for minor variance, or I didn't know there was a time frame. Is that usual?
Through the mayor, I think I need to clarify what you're asking. So you have 2 years to complete all of these conditions.
Okay.
So in this particular case, you will need to apply for a minor variance within 2 years
Okay.
of making a
And-
decision.
Okay, I think that's everything. Okay, thank you.
You're clear? You're all right with that?
Sure.
Okay.
Yes.
All right. Okay. We have no written submissions for this. Is there anyone from the public that has commented this application? Seeing none, the committee, questions from the committee? No questions? Oh, Councillor Moyer?
Just to clarify the minor variance, so she'd have to have the minor variance done before she built the new garage.
Okay, so is that another meeting?
I just want to clarify.
Yes,
that.
go ahead and clarify.
So I just want to clarify for you, Adele, that that does entail another application. It does entail another application fee. And that would be coming to Committee of Adjustments. So it's a timing thing again, right? So
So my concern is that, so the initial application was 1,800, the minor variance is 600. As part of the conditions, I understand I also have to get a survey, a new survey. So that's 1,700. And then I also have to, like, it's hard to swallow when it's two pieces of land and I own them both. That's all I'm saying. And I understand, that policy is policy, but I was just hoping for some sort of lenience in regards to being able to build the new garage in a state of flux. Just
We'd
I
be
was
looking at completing that garage this year.
yeah.
And then we'd be able to remove the other garage without having to leave everything that's in that garage out on the front lawn.
And the timing is awkward, right? Because I couldn't really apply for the minor variance until this got okayed, and then the minor variance, and then I still have to do the building. Like it's very hard to time it all. So that was sort of my question.
And we would be trying to do this as quick as possible.
Mhm.
So it wouldn't be 2 years of flux. It would be hopefully completing a building of this year and having the other one removed. So we're
Okay.
hoping to just as soon to take that now.
Is there more clarity that I get what you're asking? So is that the case, or do they have to wait for this to be completed before they can start building?
Through the mayor, I believe you can't build over two properties, so the severance
Okay, this has to
application
be
would need
severance
to be completed before you'd be in a position to get a building permit, from my understanding.
And there is a 20-day appeal period on that, even on any decision that's made to be able to start into that. Yes, yes. Okay. Let's go to questions from the committee. Go ahead, Deputy Mayor Canales.
Stephanie, and just on your last comment there about not being able to build, but given that they own both properties, does that have any bearing on any flexibility? I mean, they own them both.
So through the mayor, my evaluation, so the current structure that's on the vacant, but not vacant, the parcel that just contains the accessory building is in compliance with the zoning bylaw today. No issues. When the application before us is shifting the lot line, we're having a zoning compliance issue, which needs to be addressed in some form of way in order to be in a position to approve it. So I did provide some flexibility, whether it be the structure be removed, which I understand is not the option, not ideal an option anyways, or that a variance be applied for, so that it is, so this one can go through.
Okay.
And I think the question is, can this all be done in time to be able to build this year? I think that's what the concern is, correct?
Yes.
Other questions? But we're dealing with tonight is this application. All right, to move forward. No other questions? We have a recommendation in front of us. I did ask for public comment, yes. We have a recommendation moved by Councillor McClinchy, seconded by Councillor Hemming. In favor. We get the process started. And there is a 20-day appeal period, as the clerk had mentioned.
Yep.
Okay, thank you.
Thank
Have a
you.
good evening.
Yeah.
Our next item is notice of public meeting. Consider application MV-2-2022 located at 164 Catherine Street. That is Zelenka Primo Limited, and it's Caitlin Crowley, I believe. Is she coming on online? Okay. We'll just wait for her to join us. We're ready to go. Okay, Stephanie, if you'd start, please.
Thank you. So the applicants are proposing to construct, I guess I should start with I'll toggle between two screens here. So up in front of you is a location map identifying the subject lands. So north of Ardross Street and on Catherine. And then I also have a concept plan, which I am able to show you. There we go. It's changed on the screen. So the applicants are proposing to construct a semi-detached building on the subject lands with a lot frontage of approximately 8.3 meters per dwelling unit, whereas the minimum lot frontage required in the R1 zone for each dwelling unit for a semi-detached is 9 meters. The agent has advised that subsequent to the construction of the semi-detached dwelling, a severance or a part lot control application will be applied for that would result in 1 dwelling unit per lot. Staff have reviewed the application against the 4 tests of a minor variance and are of the opinion that it is considered to be minor in nature, it is an appropriate use of the land, and it is consistent with the North Middlesex official plan and zoning bylaw. As you can see on the concept plan provided, it is very detailed and staff did review for zoning compliance. There's no other deficiencies recognized to be needed in that the side yard setbacks are still able to be met, as well as lot coverage, etc. Notice of the application has been circulated in accordance to the requirements of the Planning Act, and staff did receive the following from Public Works. So from the water side of things, there is a water main fronting the subject lands. In considering the proposed future use, each unit will be solely and independently connected to the fronting water main to the satisfaction of the municipality. The connections from the main to the property line must be established in working order prior to the issuance of future building permits. The cost for the new water service, including any and all restoration caused by connecting works, will be at the sole cost of the applicant to the satisfaction of the municipality. A roadwork allowance permit must be applied for and granted prior to any works being completed within the municipal right-of-way. From a roads perspective, access to the lands are from Catherine Street. Access to the property are proposed to be utilized by a shared driveway, which you can see demonstrated on the concept plan before you. The owner will be responsible for all restoration costs for the creation of new access, subject to the satisfaction of the municipality. And again, any road works will require a permit. From the drainage side of things, the lands are assessed to a municipal drain, the Cameron Gillies drain. Please be advised that the owner, should the owner sever the lands, an assessment will be required. Sanitary sewer system. There is a sanitary sewer fronting the subject lands. In considering the proposed future use, each unit must be separately serviced to the satisfaction of the municipality and need to be demonstrated that the existing lines are in working order prior to the issuance of any building permits, and again at the cost of the applicant. From a municipal storm infrastructure perspective, there is not a sufficiently sized stormwater and or stormwater system fronting the subject lands. In considering the proposed future use, each unit establishes, conveys, and manages their stormwater on each property. And at the current time, the subject lands cannot hook into the fronting storm sewer system. Lot grading and drainage plans will need to be submitted as part of the building permit process. The North Middlesex Chief Building Official noted again that separate services for each unit will need to be completed, and a demolition permit will need to be required for the existing house on the subject lands, which you can see faintly perhaps in the background here, what's currently on the subject lands. The hydro and generally all services should be separate as well. The Asable Bayfield Conservation Authority has no concerns, and at the time of writing the subject report, no written comments from the public have been received. So it is recommended that the application be granted. Thank you.
Thank you, Stephanie. At this time, the applicant have anything you'd like to add?
Through you, Mr. Mayor, this is Caitlin Crowley, planner with Salinka Pre-EMO. I just wanted to thank Stephanie for her work on this project and just note that we have read the staff report and agree with staff's recommendation and would urge the committee to do the same. I will be here to answer any questions that the committee or public may have.
Thank you. At this time, is there any comments from the public on this application? Seeing none. Questions, comments from council on this application? No questions, no comments on this one? We have a recommendation in front of us to grant this application. Moved by Councillor McClinchy, seconded by Councillor Keough. In favor? Carried. Thank you. Thank you very much. We do have 6.4, a notice of public meeting to consider application MV-3-2022 located at 2095 Mount Carmel Road. And the owner is Nicholson Walden Incorporated. And I see Mr. Hendricks is here as well as Rod.
That's correct, Mr. Mayor. Thank you.
Welcome. Stephanie?
Bring my video on. All right. So the purpose and effect of this application is to seek relief from the North Middlesex zoning bylaw in order to permit the construction of a single detached dwelling on an existing lot of record in an agricultural area that does not meet the required MDS1 setback from an abutting livestock operation. The subject lands currently comprise of an area of approximately 0.27 hectares or 0.67 acres and are located on the south side of Mount Carmel Drive, east of Grand Bend Road, and also the hamlet of Harbit. The surrounding lands are predominantly agricultural in nature, with several single detached residential dwellings being located in the area of the subject lands. Based off of the data found within the property file, the subject lands are considered to be an existing lot of record that was created in 1976. And there was evidence, again, within the property files to demonstrate a mobile home was placed on the subject lands at that time in 1976, as well as a two-car garage was established on the subject lands accessory to the mobile home. And the applicant did provide some supplementary information that the home was demolished and the lands have been vacant of the residential unit ever since. And the accessory building was more recently demolished when the new owner took possession. The applicant has provided MDS1 calculations as part of the application that identifies the livestock operation being located at 2119 Mount Carmel Drive as being comprised of a barn with an area of approximately 706 square meters or 7,600 square feet that is capable of housing approximately 190 cattle with outdoor uncovered solid manure, which does require a setback of 243 meters or 799 feet. And the applicant has requested a setback of 90 meters or 295 square feet. It is noted that Section 2 of the MDS guidelines state that the information used to carry out an MDS1 calculation must reflect the circumstances at the time that the municipality deems the planning or building permit application complete. And the same holds true, for MDS2 calculations. It is noted that MDS1 setbacks and MDS2 setbacks within the guidelines are generally discouraged. However, it may be appropriate to consider reduction to MDS1 distances in situations where MDS1 is being applied in the context of expanding or existing or approved development. It is only appropriate to consider reductions to MDS1 setbacks when reasonable alternative locations are limited and where there is an attempt to reduce potential odor conflicts while balancing or mitigating against other potential concerns. The interpretation of what is considered to be minor is not necessarily based on the extent to which the zoning bylaw is varied, but rather may also be based on the impact and effect of the proposed variance. The intent of MDS separation distances is to prevent land use conflict from an odor perspective between agricultural and residential land uses. Staff, though, note that a new residential lot is not being created in this instance. We are discussing a subject lands that are an existing lot of record that has historically contained a residential dwelling unit. Staff have worked with the applicant to ensure that the dwelling is located as far away as possible as the livestock operation, while maintaining the internal side yard setback requirements. And as you can see from the property highlighted in front of you, there are not any alternative locations for the dwelling to be located on this particular property, given the size. Staff note that there are a few dwellings in the area, 2 of which are highlighted on your screen, but I should have provided a bit more of a zoomed out version for this evening. There is also the settlement area that's approximately 500 to 600 meters away from this property as well, and that is the settlement area of Corbett. Staff have examined, as mentioned, the greater context of the surrounding farming operation. And although the subject lands and the proposed dwelling will be the closest dwelling on a separate farm parcel in proximity to the existing dwelling operation, staff are of the opinion that the impacts to the livestock operation and potential for future expansion will be minimal given the number of existing residences and the location of the settlement area, the proximity, of the settlement area to the location of the livestock. The minimum distance separation publication or guidelines states that MDS 1 setbacks should not be reduced except for limited site-specific circumstances. And in this instance, the subject lands are an existing lot of record with a lot size of 0.67 acres, which is not a suitable size for agricultural uses. The subject lands were created in 1976 and it contained a mobile home, which indicates that the intended use was for residential purposes. Given the historic residential use of the lands, the size of the subject lands, and the prevalence of existing residential dwellings in the immediate area, staff do not anticipate the proposed dwelling to further hinder the ability for the existing livestock operation to expand in the future beyond reason, and therefore are of the opinion that the variance is considered to be appropriate for the subject lands. Staff note that a new residential lot is not proposed to be created, but rather a new dwelling to be constructed on an existing record abutting, existing lot of record that abuts a livestock operation. Given the unique circumstance of this existing lot of record, as well as the close proximity to the hamlet of Corbett, staff do not anticipate the existing livestock operation to sustainably increase in size without impacting the existing surrounding dwellings, regardless if this dwelling is constructed or not. Land use conflicts as a result of the additional dwelling are anticipated to be minimal, and staff have in order to assist in mitigating any potential land use conflicts, have suggested conditions that would further mitigate any land use conflict, being making sure that the 14 meters setback from the property line, the shared boundary, is put into place, and that a row of trees be planted along the shared boundary line. And the applicant has indicated that they will be implementing a air conditioning unit to prevent the need for opening windows, etc. And staff have included that as a condition for the application as well. Again, and that's to address any potential land use conflicts and reducing that. Notice of the application has been circulated in accordance to the requirements of the Planning Act, and staff received the following comments. The Sauble Bayfield Conservation Authority has no concerns. North Middlesex Public Works Department did note that there's water fronting the subject lands and will be required to hook up should the dwelling be built in the future. In regards to roads, the lands do have an existing access off of Mount Carmel Drive. The North Middlesex Chief Building Official has no objections. And at the time of writing the subject report, staff did receive a written objection letter from the property owner at 2119 Mount Carmel, which expressed concerns in regards to the impact of future agricultural viability as a result of the variance. The full written submission has been attached to the council agenda for reference, and I believe we do have representation this evening who can speak to that. No other written submissions were received at the time of writing the subject report. So it is recommended that the application be granted, subject to the 3 conditions which council will have before them. Thank you.
Thank you, Stephanie. At this time, the applicant, would you like to have comment?
Thank you, Mr. Mayor. Thank you, council. Just for the record, as indicated by the mayor, my name is Paul Hendricks, Hendrikx, here on behalf of the applicant. And I would also note, as was pointed out by the mayor, that the president of the corporation, the corporate applicant, is present as well if there's any questions for him. First, I just want to thank the planner for providing the detailed report, which we are generally in agreement with. There is one thing that I just want to put on the record as a clarification, and then I have a few items that I just wanted to address before we open it up to council to ask any questions. So the only thing that, and it's not necessarily a disagreement because I certainly don't have any documentation to modify what's in the planner's report, but I did want to, and I don't think anything turns on this because I think everybody's in agreement that the lot was used as a residential lot. But my client was told by the seller of the property that it wasn't a mobile home, but a freestanding house that was on the property and then subsequently was demolished. As for the other matters, one thing, and I would like to reserve the ability to make any comments if there's further comments made by the party who's objecting. But based on the letter of objection, I think all of the issues identified in that letter are addressed in the planner's report. But I would point out that it seems from the letter to be indicating that the barn is currently, in fact, empty and has been for over 2 years. The remaining comments, I just want to make, reiterate what the planner had said. We need to look at the greater context here and the proximity to the settlement area of Corbett, which is very close to the barn as well. These are quite unique circumstances. So while minor variances of this nature are not granted frequently, I think this is one where it meets all the requirements as agreed by the planner. And just to expand a little bit on the planner's comment that further expansion of the agricultural complex where the barn is already located will have a number of issues because there are existing dwellings in addition to the one we're proposing that are within the minimum setback distance calculations of just the existing structure. And I just want to put on the record and ensure that council knows that the existing residence immediately adjacent to this property is more than 100 meters closer to the barn than the minimum distance separation calculation that was provided. So we're already well within that with the existing residences. Again, as noted by the planner, if we aren't able to construct a dwelling on this property, there is essentially no practical use for the property. So it would have the effect of creating a useless small lot. I also want to just note to council that we are in agreement with the conditions that were suggested by the planner, including the planting of trees on the property line. So if the mayor or council has any questions, I'm happy to entertain them now.
Okay. We'll take comments from public first, and then council will get to ask questions last. So at this time, comments from the public. Go ahead. Do we have a microphone for,
Would you like us to move so that they?
if you
Yeah,
wouldn't
no, that's
mind,
okay.
just for a minute, if you'd like to come up, Mr. Hodge, just come on up. And
Thank you, Mr. Mayor. I'm David Hodgins, the owner of 2119 Carmel Drive. This is my daughter, Emily. She's part of the operation. I guess I'll start with the background of the property beside me, because what has been said about it is starting to make more sense, because what was in the planning is completely gone south. As to the lot 2019 Carmel Drive, 2019 was one large lot owned by Gordon Young up until 1976. He applied to have the lot split into two, so his son Keith would have a place to live. And that become lot 21 or 2091. At that time, in 1976, he did put a mobile home on that lot. In 1978, he replaced the mobile home with a double wide poured cement foundation. Because he was in need of a place to live because the rentals were not available. Lot 2095 had a wood framed house, wood sided, that was dated back to the 1940s or later. I don't know the exact date of it. It also had a hitching shed on the back, dated back to the 1940s on lot 2095. Lot 2095 was rented out in 1985 by the Youngs as his parents, one had passed away, the other moved to Park Hill. And it was gutted by fire in 1986. At this time, Keith Young applied for a building permit to build a two-car garage on his lot 2091 beside his double wide. He used the old lumber out of the gutted house to build a lot, the gutted house on lot 2095 to build a lot on his lot 2091. It was noted then with the township that if this house on lot 2095 was not rebuilt on lot 2095, then it would not be allowed in the future with new laws for livestock setbacks, that they were becoming more strict. Lot 2095 did not house a mobile home at all on this place. The hitching shed then was demolished by the present owner in the fall of 2021. The Young family tried to sell the lot 2095 15 years ago and were not successful, as the township would not allow a building residence to take place on this lot. When the lot 2095 was listed for sale in August 2021, I called Middlesex Center, talked to Arnie Marsman, head of the planning development. He informed me that no house could be built on this lot 2095 because the livestock barn on my property was at 2119 was too close. Nor could the existing house on 2091 grow any bigger than its current footprint today due to the livestock minimum distance setbacks. He informed me that if I wished I could buy lot 2095, but I would have to join lot 2095 with lot 2119 to be able to build a home for a family member or a worker that was working for me. I had also contacted the real estate rep to double check that this lot, because it does not meet the zoning bylaw exemptions. I sent him a copy of the exemptions. He said it was good to go with the township. My property, lot 2119, houses beef cattle barn requiring these setbacks. Currently, members of my family and myself are in the works of expanding our farming operations with the intent to expand the facilities on 2119. As I'm already dealing with the nuisance complaints regarding noise and odors
as well as no regard for private property on other lands that I own and rent around the area. I was told that I would be kept up to date on what was going to happen with the mix-up on lot 2095, as the new owners have a right to apply for minor variance, but if I was not in agreement with it, then it will not work. Going forward, the municipality would have to figure out what they were going to do with the lot, but unfortunately, this did not happen. The municipality made no effort to keep me up to date on this matter. I only received a letter of intent for minor variance on April 5th, 2022. It is not my problem or Mr. Nicholson Walden's problem that a new inexperienced planner for the building department of North Middlesex did not do his job and investigate the property further before issuing a building permit. I should have to put in this position that I cannot expand my operation in the future without any added costs or special permits. We're losing enough farmland every year to new homes around the cities, let alone putting a squeeze on us out in the country. With new government mandates in effect on fertilizer, that means more manure spreading. I hope that you are taking that into account, as well as on country dwellings. I will say again, I am completely against the minor variance. And upon what Mr. Nicholson and them had said, I do not put up with trees planted on a lot line because they plug tile. It will be a cedar hedge if there ever is anything built there. And second of all, the house that was on that property was only 6 feet from the property line at the road. And that was a problem back in that day for building the build on it. Second of all, on the south side of that building was a well on the property behind by the house. And it has never been decommissioned. That property was never cleaned up properly. They just buried the foundation, and there is a well still buried there that has not been decommissioned. And then behind where he's going to put his house, there is drains that go into the municipal drain that goes through the 2091 lot cornerways.
All right. I'm going to give the applicant an opportunity to speak to your comments.
Yep.
Okay. And I guess, Mr. Hendricks, if you come back up here, if we can do that, let him have the floor. We got to get another microphone for public to be able to do this better. But go ahead and respond to this.
Thank you, Mr. Mayor. Just a few comments. There's a number of things that I can't really comment. I'm hearing them for the first time, and it's, essentially much of it is hearsay. So it would be difficult for me to refute it in the first place. But a few things that I can comment on, it does seem, and that kind of explains the clarification that I had made at the outset, that we weren't totally sure exactly the nature of how it was used as a residential property. But I think it's clear, even from Mr. Hodgins' submissions, that there was a residence on that lot. He made reference to the fact that you shouldn't grant the minor variance because then he won't be able to expand his operation. And I just want to reiterate the comments that were made by the planner and that I had made earlier, that he is going to have significant problems expanding regardless of whether this minor variance is granted, because we already have a residence more than 100 meters within the minimum distance separation of the existing barn, let alone putting an additional barn on that property. So I completely disagree with the characterization that not granting this minor variance is going to allow him to expand as he wants. And if he's making it a minor variance application similar to what we're doing to expand, it will be before the same council that's considered this application. So you can take that into account when considering that application. I can't comment as to the well comment. I'm not sure whether there is a non-decommissioned well on the property. And I wasn't totally sure I followed his comment about the drains at the back of the property. But I don't believe there's any tiles within the lot that we're dealing with.
I believe Mr. Hodgins mentioned about a municipal drain along the corner of 2021, correct?
It's not a municipal, it's 8-inch main.
8-inch main, sorry, farm drain.
And that's where the drains on the back part of the property, they dug some of them back 2 years ago to get rid of water behind the kitchen shed.
Okay, thank you.
And that's located at the back of the property? Is that? Yeah.
Let's speak through the chair, all right? so
Oh,
we don't
sorry,
go-
sorry, I
Just
apologize.
so we don't go back and forth. Yep.
So I'm still not clear exactly where it's located. I don't think it's going to interfere with the construction of the residence.
Okay, thank you. I'm going to open this up for council, for questions from council. Who'd like to start? Deputy Mayor Nelson, you go ahead, start.
Thank you, Mayor Rob. My question is directed to the planner, and has some confusion around the MDS rules. The letter that was submitted by Donnelly and Murphy addresses a similar issue that we dealt with some time ago on Elm Tree. And I'm struggling with the difference between the two proposals in that the one was recommended to be denied, even though that structure was significantly further apart than this one. And I need to have some clarity or better understanding of why this one is recommended to be approved and that one was not.
Through the mayor, I guess I will firstly start by, this application is dealing with MDS 1, which is where a new dwelling is being situated in proximity to an existing livestock operation, whereas the file you're referring to was the opposite, so MDS 2. But it does go both ways in that land use compatibility is the end goal of the MDS, regardless of which way it is occurring. I would note that each situation is different and evaluated independently, and is also largely based on the type of livestock that occurs and the quantity, and that determines generally the required setbacks. So in this case, we're dealing with cattle, which is generally less odorous than swine would be, and therefore a smaller setback requirement than the swine would be. So it really is dependent on the type of livestock and the different odor potential values. And that is all indicated in detail in the minimum distance separation guideline by the province.
Thank you. I guess you've explained it rather well. It's my shortcoming in that I don't understand the discrepancy between MDS 1 and MDS 2. Is that addressing livestock? Is that addressing the fact that the residence was there prior? And how does that impact on this, considering that the other was a livestock barn that was there as well? And so I'm struggling with defining the difference between the two MDSs.
Just a minute, Mr. Hodgins. What we'll do is council will, if there's questions directed to you, and we'll give you another opportunity after. Okay. Go ahead, carry on.
Can you give me just a brief insight into the difference between MDS 1 and MDS 2?
Through the mayor to the councillor, I think I'm going to need some more direction other than if I'm not answering the question correctly, I'm not quite sure what else you're looking for. If you could provide me with some more guidance.
Well, I guess my question is that in this particular application, you refer, I believe it is to MDS 1. On the one on Elm Tree, you refer to it as MDS 2. And so what I'm struggling with is what I don't understand is the difference between MDS 1 and MDS 2. And you made reference to that, so help me understand what is the difference between the two MDSs?
So through the mayor to the councillor, perhaps I can expand upon my previous explanation. So MDS has OMAFRA has a tool that generates MDS calculations. There's a bunch of factors that go into it. I mentioned the type of livestock, the quantity. There are other factors for manure type of storage. Generally, from my understanding, MDS 1, when you're introducing a house towards livestock, is nearly double the required setback in comparison to MDS 2.
Did I understand you to say that introducing a house would require double the MDS than you would otherwise?
Through the mayor, that's correct. And that's, from my understanding, to largely protect the farmer to have the ability to expand in the future.
Thank you very much.
Other questions? Councillor Hemming.
Oh, thank you, Mayor Rob. So I'm kind of lost, like Adrian is a little bit on this distance in the MDS thing. You say that the MDS is minor in nature, or sorry, the request is minor in nature. When am I right in saying normally it should be 243 meters, and he's requesting 90 meters? That's, to me, that's not minor at all, but that's just me. So could you explain how that is deemed minor?
Sure.
Thank you.
Through the mayor, as mentioned, what's considered to be minor is not necessarily the extent from which the setback is varied, but rather the impact. So right in the MBS guidelines, I'll provide a quote from you, which I think speaks exactly to what you're referring to. So determining if a proposed reduction in MBS setbacks is minor depends on the context in which the reduction is being proposed. Minor means different things to different people, and OMAFRA does not endorse a specific percent decrease, 5%, 10%, etc. So in some circumstances, a very small reduction in an MDS setback may not be considered minor given the surrounding land use and potential odor conflicts, where in other instances, a significant reduction in MDS setback may be considered minor. So the perception of what is small or minor in nature will vary depending on the local and site-specific circumstances.
Other questions? Councillor Moyer and then the deputy mayor.
So the minimum distance separation, if this operation was to expand, the property on 2091 would still be sort of the stipulating distance there. So if the operation wants to expand, they would still have to be to the east of the existing barns. And that would be the property that would dictate the distance.
So through the mayor to the councillor, so this MDS file has been evaluated under the existing circumstances today. I don't personally have details on what would be proposed in the future, but certainly staff would evaluate what's being proposed, the size, etc. In the future, and should it need a variance. I have not received personally any plans in detail that would indicate the MDS calculations or whether or not a variance is needed at this point in time. But certainly, as mentioned, it's kind of a first come, first serve in regards to the agricultural area and residences and agricultural uses. And certainly, while there is protection overall and encouragement of protection for the agricultural industry as a whole, staff recommendation and hopefully the intent of including some conditions to help offset or mitigate is certainly, in my opinion, within the with keeping in the intent of the document, which does speak to variances sometimes being accepted if there are no alternative areas or proposals to locate a dwelling, and if efforts are being made to mitigate any land use conflicts. Thank you.
Okay, so I guess the 2095 would really have a very minor effect on any future farm expansion because of the close proximity to 2091 as well.
Through the mayor, I can't make comment at this point in time of any impact of future expansions from 21119 on existing dwellings, but certainly, yes, there's probably a 20-meter difference between the existing dwelling at 2091 and the proposed at 2095. So they are very close in proximity.
Okay.
Thank you.
Deputy Mayor Cornelison.
Thank you, Mayor Rob. I believe my question may be directed more at staff, I think, because Mr. Hodges made reference to a determination made by the former McGilvery Township that if the dwelling unit were to be removed back then, that it could not be reestablished. Is there any method or opportunity to explore that to see if that is the case?
Through your worship to the deputy mayor, I would trust in the evaluation report from the planner. She did go through the property file. It would be subject to a note, I would believe, in there or some special provision under our official plan. But again, we're dealing with legacy issues that we could certainly look into. But I would say that the lot fabrication as presented is existing and the minor variance requested before you is for your consideration. So the lot's there. Whether a building dwelling unit could be established on it or was an understanding that another one could not be established, I couldn't speak to that right now.
In addition, Mr. Hodges also commented that he was approached previously because at the time that the seller of this property was advised that the home or nothing could be constructed, a home dwelling could not be constructed on that property. And I believe that was like 2 years ago, or maybe 3 years ago, I don't recall. What has changed in the meantime that can occur now?
Through your worship to the deputy mayor, again, this is a little bit of a hearsay situation, but the matter considered before you to relieve a minor variance would subsequently allow the dwelling unit to be erected. So I'd be hard pressed to say that it was conveyed that way. If the MDS calculation was overriding, some examination into the file would pertain that again, the lot exists and that there is an avenue being considered today similar to a minor variance. So the answer I would give 2 years ago if it came to me would be you would have to request a minor variance before you were issued a building permit.
Thank you.
Other questions? No other questions right now. I would have a comment. There was a question about a well in that property. Is there any way that there's another stipulation in there, if there is a well, that it is decommissioned properly?
Through the mayor to add as a condition,
Yeah, that's what I'm.
that could be considered. However, I'm struggling to see the correlation between that and this file
Okay.
myself. It
Okay.
could be addressed likely through the building permit process. We
Okay.
did receive comments that there's municipal water there. So I imagine through the building permit process, they will be required to connect.
Oh.
I can't speak too much to the decommissioning. I'm not sure if that's.
Well, if that goes in the building, goes into the building profile, that's different. I just wanted to know if it needed to be on this. It doesn't, on the sound of it, correct?
Through your worship, wells and abandoning wells are more of a provincial level. Although we are part and parcel to identify them to a certain way, we're not the authority to ensure that they're decommissioned and registered with the province. And there's a lot of remnant wells out there. That certainly can be noted and we can be identified on as a site condition. I think that's what the planner is suggesting, that we kind of carry it forward that way for future investigation.
Well, in honesty, I'm more concerned about a kid falling down into a well that nobody's aware of. Never mind regulations. I'm more concerned that nobody gets hurt in it. That's the. But
Thank you, your worship. If I may, and I'll ask my client to confirm this, but I'm not aware of any well casing or older cement well above ground on the property or below. I'm not aware of either, but as far as we're aware, we've never seen any evidence of a well.
okay, it was just a comment that I remember through the. Mr. Hodges, you've asked to speak again. I'm going to allow that. Go ahead.
Well, was just south of the porch, you went out, and it was a whatever board, well, it wasn't enough with black water, so it wasn't good water. My parents back in the day, they dug a water line from our place, that place to feed them for water for years, because we had a good rock wall. And that was done in good faith. And same, the division of that lot was done in good faith because his son was living in one of my father's residence and family was growing. And they agreed to split that, so we had a place to live because we was nothing available at the time.
Okay, thank you.
And second of all, the barn, we have kept pigs in the past. We haven't been limited to just cattle. My daughter has been applied for the last couple of years for the new entry program for chickens. To possibly put up a chicken facility if we get accepted. And there's nothing saying we can't go back and fix the fire built for either or.
Okay, no, thank you. Other questions from council? There's no question that this is not a win-win situation here. I mean, that's why it's come to council, and it's a tough decision to make, but if you have other questions, please ask them now. None? All right, we have a recommendation in front of you. What is your wish? We're looking for a mover?
Motion. May I make a motion, Mayor?
Yes.
Mr. Mayor, my motion would be to deny the application. While I want to be strongly supportive of investing and constructing of new homes in our community, I feel that agriculture is our driving force and is the main business in our community, and we need to support our agriculture industry. On that basis, I would make a motion that this application be denied.
Okay, thank you. Is there a seconder for that? You're seconding that, Councillor Keel? Okay, discussion on that? Okay, the motion is deny. In favor? For opposed? That motion is carried. And as all, go ahead. Go ahead, Jackie.
So just to remind that if you do require a notice of decision, that you make a written submission to the clerk's office. There is a 20-day appeal period that will apply from the date of the decision, and we'll be processing that within the next couple days, but okay.
Thank you.
Thank you.
Thanks, Stephanie. Oh, yeah, we have to adjourn to go back to a regular meeting. Motion to adjourn this, go back to regular. Councillor Hemming, Councillor Necko, in favor? Carry. Our next report is the Manager of Recreation and Facilities, the Parks and Recreation Master Plan. Hey, Brandon.
Thank you. Through the mayor to members of council, the report in front of you is the results of the tender submission for the Parks and Recreation Master Plan as approved in the 2022 capital budget. The plan was tendered out in late March, and we received 3 submissions. The 3 submissions were from Monteith Brown out of London, PRC Solutions out of Hamilton, and Stanek out of Toronto. As you can see, the proposals were evaluated by a committee. The committee consisted of Amber Tiller, Kathy Wilmsey, Jonathan Graham, and myself. Each committee member scored these plans separately, and then the averages were formed to make a scorecard. The results of the scorecard were Monteith Brown at 86.5 points out of 100, PRC Solutions at 85.75 points out of a possible 100, and Stanek Solutions at 85.125 out of a possible 100. The prices were all within 10% and all came in under budget. The one thing that staff did note is that Monteith Brown's plan assigned about 100 extra hours of staff time. So yeah, the winning proposal was Monteith Brown, and if there's any questions.
Questions from council? Deputy Mayor Canellis.
Thank you, Mayor Rob. Is there a time frame for this this master plan to be completed?
So the master plan schedule that was submitted by Monteith Brown would see major consultation done throughout the summer months. We're hoping to hit our Gala Days Festival, the Park Hill Fall Fair, as well as hopefully the car show to gather public feedback. Late August, early September, we hope to have a draft plan to council. There will be consultation with council beforehand, as well as community groups, major stakeholders and such, and then the hopeful final plan in the fall.
And just to refresh my memory, what is the benefit to the community for this master plan?
So the benefit to the community is it provides a framework across 10 years to help us in grant submission. Many municipalities have seen favorable funding, such as the ICIP grant for new arenas, for new community centers, and a lot of times what they ask for is supporting documentation. Supporting documentation usually entails a master plan. Sometimes people have feasibility studies. It basically gathers their feedback and will say, what the community wants, what they're looking for. Are they looking for more trails? Do we have too many facilities to serve our current population? Do we have not enough programming to serve our population? What does our population desire? What do other municipalities in the same size offer? Are we ahead of them? Are we behind them? As we grow, where should our benchmarks be at population 10,000? What should we be looking towards? Those kind of milestones.
Thank you.
Other questions? Other questions? Seeing no other questions, we have a recommendation in front of us. What's your wish? Moved by Counselor Nickel, seconded by Counselor Hemming. All in favor? Carried. Thanks, Brandon. We do have our first quarter building activity summary. And I believe we do have Arnie Marzer with us. How are you, Arnie?
Good evening, Mayor. Thank you for having me. I'm doing great. Thank you. So I'm here tonight. I'm happy to be here to present to you the first quarter building report for North Middlesex. A quick review of building permit activity in the first quarter shows us very healthy and really on target with what we had last year. And looking ahead, I think this year we should be a bit more active than last with new development, new dwellings. So certainly have a lot of numbers there in the presentation if anyone has any questions about the staff report, but I'm happy to answer them.
Questions for our building official? Deputy Mayor Nelson?
Thank you, Mayor Rob. Arnie, I'm looking at the report here, and one thing that piqued my interest was the agricultural buildings. I think there was 13 number of permits, but it's just 4.5 million. That seems rather low for agricultural structures. Is there just smaller scale buildings going up?
Great question. Through the mayor, I can't honestly speak to specifics. Not because I can't, I don't want to, but because I don't know the details specifically. But it may seem like a low number. I unfortunately can't explain why. But yeah, I suspect it's just number of smaller drive sheds is what we're looking at right now. No major buildings at this time.
Okay, thank you.
Any other questions for a building official? No other questions. We have a recommendation in front of us to accept the report. Moved by Councillor Moyer, second by Councillor McClinchy. All in favor? Carried. Thank you very much, Arnie.
Okay, thank you.
Our next is receipt of accounts, and that's our treasurer, Estelle. Yep.
Am I on, Jonathan?
Yes, yes, you are.
Yes, you are, and loud.
Oh, I'm sorry. Thank you,
No,
Mr.
that's
Mayor,
our
members of council. The report that you have in front of you outlines the municipality's expenses for the period of April 15th to the 28th, totaling $487,288.17. Are there any questions?
Specific questions? Councillor Nickel?
There seems to be a lot of tax refunds on this. Can you explain that to me? Why? Not
Through the mayor
to the
to-
individuals, but just in general.
Yeah, absolutely. Through the mayor to the councillor, the tax refunds that you see on this report are due to a reclassification of the properties from residential to farmland following an application from the resident to AgriCorp. Now, usually we would just carry the credit until the final tax billing is done. But in this case, there was a change of ownership and the credit would be due to the previous owner, which is why we went ahead and proceeded with refunds.
Thank you.
Okay. Deputy Mayor Ellison, you had a question.
Councilor Nicoll asked my question. Thank you.
Oh, okay. Other questions? No other questions? We need a recommendation to move the report. Councillor Keogh and seconded by Councillor McClinchy. All in favor? Carried. Thanks, Estelle.
Thank you. Have a good night.
Good night. Committee reports. Lake Huron Primary. ABCA.
Thank you, Mayor Rupp. I just wanted to make mention that the ABCA, they're beginning to enact the change in the Conservation Act that has been established. And I don't know what impact, I don't know if the CEO has any comments on the impact it'll have on the municipality.
Through your worship to the deputy mayor, I haven't had any further conversations since the last time I received notification that they'd be reaching out to me at the appropriate time, which I would suspect would probably be in the next month from the change in the legislation that I've seen today.
Yes, it's just, I was mentioning to our rec manager that a point of interest that they were discussing education opportunities for our community, but my understanding is that there may be a fee for that service.
Again, through your worship to the deputy mayor, there's a lot of funding models that are being left in the lurch right now from the provincial government. And although I do agree that the education component is very important and valid, there may be a fee associated with that when they mobilize regionally. I would suspect that if that is the case, that we, through a budgetary process, we would allocate and we would identify a rotation through the schools so that there's an ample opportunity for everybody to take advantage. But as of right now, I know they're looking for cost saving measures, and that's one of the ones that was on the docket.
Yeah, I don't think we want to lose that educational portion that they go through the schools, so we'll have to see what. Is there any questions for ABCA for Adrian? Seeing none. Blue Water Recycling, their annual report is there.
They did well this year, but they have to tie in agreements as far as the cost goes, with gas, diesel, everything else, truck drivers and vehicles, but things are gonna change down the road. The council may have to make decisions on which is the best way of going, because we're gonna more or less amalgamate a lot of the services and that. So it's all in the report if you want.
Okay.
You didn't really go into detail, but I think the next term of council will be to make some decisions.
And I did see they talked a lot about shortage of drivers and different things like that there, that they've had trucks that haven't actually been able to go on the road because guys are doing double runs. Yeah. They've been very forward thinking though, with didn't you say just over half of his fleet is on natural gas now from gasoline? So they have been forward thinking that way.
Francis did say that when employees don't show up, they got robots. They show up all the time.
Okay. Well, I don't know what
It was funny, but it wasn't funny.
Right.
You know what I mean? Because they
Yeah.
have to have them.
Yeah.
If it's due to illness or whatever, maybe they got the robots to continue to work.
Yeah.
But it was really interesting.
Okay. Any questions for Councilor McClinchy? Seeing none, thank you, Doreen. EDAC, anything there? Nothing there. Local school advisory? Okay. Recreation committee? Policies? We have nothing there. The fire committee?
We did have a meeting last week, Mayor Rob, and the minutes should be coming through here in the next week or two.
Okay, all right. Maybe for the next meeting, we'll have them. We'll see. Okay,
Yeah, I think the draft minutes are ready to go.
okay,
They just need to be inserted.
okay. Thank you. Correspondence, Ministry of Environment, Conservation and Parks, regulations and policies under the Conservation Authorities Act. Any questions on that? That's a moving target right now. That's what we were just hinting on here, right? Township of Ashfield, Colburn, Wallanosh. That's a mouthful, isn't it, to say where you work? Invitation to the 2022 Municipal Night at Kings Ridge Center. Just for, if anybody wants to go, I think we do have to RSVP on that if we're going. Municipal Property Assessment Corporation, 2021 financial statements. Receive and file. Transit training. That's an online, but they want 350 or 360 bucks just to sit there and to listen to it. Anyways, yeah, I didn't join it. Petition for the Park Hill 2022 Main Street Road construction. Johnson, do you want to speak to that?
Sure. Through your worship, members of council, a petition has been presented before you from the business community from the Park Hill Main Street as it relates to, I guess, seeking a public conversation, which was held on April 25th, 2020, just 2 weeks ago. We had about an hour and a half conversation. It was an open floor discussion. Then it turned into a little bit of a Q&A at the end. I think it went positively. It was the third public outreach that we've had officially, including the public consultation meeting in January and the survey. Again, it was very much dependent on identifying the stages of the construction, which are 3, the impact to the local community, and we were able to take that leap and identify that the grant has been awarded to the municipality for the Park Hill Main Street improvements. I can open the floor for any questions or comments, but that's generally a synopsis of what occurred.
Okay, now that we have got the grant, what's the time limit that we have in order to spend that money? Because there would be a time limit, correct?
Through your worship, to Councilor McClinchy, there will be a time limit, but I cannot speak to that right now because I don't have the agreement at hand. All we've been identified, and even then it's a little bit of an extension, is that we have been awarded the grant and we can depend on the grant. In other similar fashion from the provincial government, it's usually a 1-year term or less, depending on when the award is. They did shift the budget from March to April this year. I will be arguing as much as I can to have an appropriate payment schedule for our benefit, but I just don't have that agreement in hand to make those comments today.
Councillor Moyer, then Deputy Mayor.
You mentioned there's going to be in 3 stages. Can you just
Stage-
review how those 3
Stage
stages?
1 will be King Street North all the way to the reservoir.
Main Street.
Sorry, Main Street, but from King Street all the way north. Stage 2 will be King Street all the way down to Elgin Field on Park Hill Main Street. And then stage 3 will be a water main extension on Elliott Drive. The schedule as it sits right now, we are most definitely not going to hit stage 3 this year. It will be focused on stage 1 and stage 2. The last coat of asphalt will not go in 2022 as well. It will be a 2023 project. So we're really dependent on some of the funding and some of the announcements coming through. But the schedule for if all things being equal works out, would be after the July long weekend, we would be breaking ground on stage 1.
But that would be capped by the fall, and there would be.
We have to cap it. We will be capping it.
This will be accessible during.
Sidewalks will be
construction
accessible as long as we can keep them. Without having the tender award, we can't schedule the works with the contractor. We also need to identify how the staging of the works will go. It's not going to be the entire block by block. It's not going to be the entire project on its whole. That's why the stages, but it will most likely be a couple of blocks at a time, just to keep rolling ahead. Hard surface will be removed appropriately, but depends on again on the contracting firm that we are successful to get. And that I should note that because of the scale of the project, that does have to go back to council for the contract award, which will have provisions identifying schedule, scope, some nuances in terms of the uniqueness of the individual who will be taking on the project, because we are putting in provisions related to retention for business community as much as possible.
Okay, Deputy Mayor Nelson.
Thank you, Mayor Rob. Jonathan, the question I have, actually I have 2 questions, but I'll start with the first one. And that is that this year seems to be a challenge to secure contractors to actually do the work. And given the timeframe that we're looking at, we're already into May and the announcement hasn't really come forth yet. And the tender has been put out yet. Is it realistic that we can actually obtain or secure a contractor to initiate construction in July, or would it be later?
Through your worship to the deputy mayor, when we were getting that sinking feeling in our stomach that the grant wasn't coming, or that the notice wasn't coming, or the dependence of the grant to the project, we actually sent out a request for qualifications. This is a large scale project. This is not an average or real project that North Middlesex takes on a regular basis. This is more of a single tier contractor. At that point, 5 contractors closed the request for qualifications, and it looks like most of them are going to meet the threshold to bid, and they're in the JR, the L82, I don't know if L82 took the project or took the contract. I apologize. But I know JR and a couple of bigger companies, Burma, did take that contract, and that they will be inviting them to tender. That being said, going back to my other comment, that you will have the tender document presented in front of you for the award, and it is up to council whether they award the project or not. But then there's a possibility we could forego the grant opportunity that's been presented.
And the second part of my question is, in at the public meeting that we held the other day, there was some discussion about changing the scope of the project from King Street to the dam to Mill Street to them, which would allow access to the businesses. Is there a significant difference for that one block?
We will be looking at, we are looking at the traffic impact in the detour. It is tricky in this, in any detour synopsis of this leg, because you are talking about human behavior and public safety at the same time. So we'll be providing an opinion to council and correspondence in future to the rationale to what the choices were and why we are suggesting going with that. Generally, the project for stage one is only a couple of months. So it's really the impact, although is in stage one for the business community, stage two is not, doesn't have very many options. We do not have the grid pattern to support some of the suggestions that have been put to date in terms of the road for the detour, in terms of safe conveyance. The other thing that we also need to allude to is that we have construction of plans of subdivision down at the south end. We will have some in the north end, but we also have the fire hall that will be a contractor site as well too. So we'll bring some of that information before council for the rationale.
Thank you.
So basically, it's all going to depend on when we award the tender and when they have the materials to start, right? You know, like, you know, this may not happen till almost August.
The plan is for the ground to break in July, August.
Well, that's what I'm
And
saying.
we, like I said, we are not going to be able to finish this project in 2022. 2023, we'll see the finer details in terms of top coat of asphalt being placed. So this is a multi-year project that will be transitioning over a period of time.
And because it's the main street, people live on east and the west side, so they have to get to their own residence. So this construction, even though it's going on, they have to provide the local traffic access to all these businesses as well as all the homes.
Through your worship to the Councillor, sorry, get tongue tied, Councillor McClinchy, we're going to try to maintain as much access as possible. I can't guarantee that you're going to have access all the time because that's the nature of construction. It is a main street corridor. Contractors will be bidding as such, and the expectation and the threshold would be to maintain access or communication to an affected resident on a regular basis. I've been in this position before as the inspector. Sometimes I would be able to get to residents and knock on their door and say, you're not going to have water tomorrow. Sometimes I wasn't able to get a hold of them, and after several attempts, unfortunately, we had to shut their water off because the construction must go on. But there is proper notice. Again, what was identified in the public meeting, 2 notices will be going out, one for Park Hill in its entirety, notifying of the construction and the schedule. The other one will be directly affected residents fronting the construction, where they'll have 3 points of contact: the inspector for SEMA, the general contractor, and then 1 representative from the municipality. Between the 3 of them, that's where the coordination happens.
Okay, anyone else? Just a last comment I'd make on this is there was other questions at that open house, but there was 3 main themes, and one was the detour route. What can we do with that? Communication was a big one. And the third one was signage as well for businesses and stuff. Those were 3 of the main questions. There was other questions as well, but those are 3 big items for people that came to that. And we had a good turnout, and people were expressed their opinions and their concerns. I thought it was a pretty good open house. I hope we can keep working with them well. So,
Well, one of the concerns was that because we're starting at the north end and we're coming down as far as Mill to work there as well. One of my concerns that I heard was that why, instead of detouring everybody from number 7 all the way around to West Park Drive, why could they not still allow cars to come up as far as Mill Street or King Street for the businesses there, and then they'd have to detour out?
and that's what I was saying. One of the
Yeah.
concerns was detour route. That was, just getting into the specifics of what their concerns were. But yeah, those were, I would say, the 3 main. There was other ones, but that was the 3 main.
We were looking at the business especially because due to COVID and that, they've been struggling for the last couple of years, but that was businesses' concern is what I got out of the whole meeting.
Absolutely. Okay. The last item on correspondence: County of Middlesex More Homes for Everyone Act, Bill 109 summary. And if you haven't looked at that, look that over real good, because that's got some pretty big implications when you look at the timeframes they're allowing. There are some fees that will have struggled meeting those timeframes, so giving back fees. So yeah, if you haven't had a chance to look at that, look that over. I believe Dirk did he did a rendition, he did a talk on that same, but it was the same slideshow that he gave. So, all right. So other business, urgent business, Jonathan.
Through the mayor to council, this matter is concerning the Merritt subdivision agreement. There's 2 agreements and 2 bylaws to be considered. And it really comes back to the remnants of a consent file that was considered in 1990. Excuse me. So the development service agreement will be one of west of Eagle Street and one of east of Eagle Street. I can tell you that this agreement pulled a lot of threads and patience from the organization in seeing it through, but I am finally happy here to say that the Merritt subdivision can be executed and deposited and that we can move forward with a developer that is eager to move ahead with the project.
And right up to the meeting time. Any questions on that for anyone? Deputy Mayor Canellis.
Jonathan, this is the same developer that's doing Westwood Estates, is it not?
I think it's public knowledge that it is, but under the numbered corporation, I believe it is a different individual, but it is the same outfit, yes.
So is the intent then to complete a portion of Westwood Estates prior to moving here, or they both would be moving forward simultaneously?
So because of the age of this file, there were provisions based off planning and engineering that we had to grandfather. So there's a faster avenue for the Merritt subdivision to break ground this year, where they only have to do linear works for storm, sanitary, and water. Phase 2, 3 on the Merritt on the Westwood Estates requires a storm pond, and we're in the midst of gaining a license right now that would speed that up, but we don't have that up to date. So I believe the intention is to shift the outfit because they're almost completely built out or reserved at phase 1 in Westwood over to Merritt, do Merritt for a little bit, scratch the earth and move back, hopefully when the license is done. So the primary focus is a stopgap in this situation so that we can get the licensing required for the Westwood Estates. Thank you.
Okay. Anything else? Okay, so that's it for Merritt. So other business, Councillor Moyer.
Yeah, I forwarded on a request for a stop sign at Adair and Cassidy Road. Before I had another inquiry on that again. The yield sign there right now and
Through your worship, I'll have to look into that again, but I do recall the email that was about 2-3 weeks ago, I believe.
Yeah.
I'll look into that. I think a work order was issued for that, but I'll follow up.
okay, thank you.
Okay, any other business? Deputy Mayor Canellis.
Yes, John. So speaking of signs, are we making any progress for the signage by the daycare for children crossing?
I believe it was ordered. I don't know if it is. It is in, so I'll check.
Thank you.
Any other business? Okay, moving on from that, deferred items are in front of you. Communications, including county council. I don't believe we've had a meeting since it was the same week as.
Actually, I think there's a couple of things, Mayor, if I'm
Okay,
not
go ahead.
mistaken, because I think Councillor Smith's motion for the sidewalks.
Yes.
I think that was interesting. The motion to incorporate some painting or identification of crosswalks throughout the county for special interest groups. So the county engineers will be undertaking a study to report back on that. The other thing I had here was the workforce strategy. There was a report came back, I think, from economic development. And one of the highlights of that was the shortage of workers in the county. You know, the shortage, like it's becoming critical that there's just not enough workers in the county at all. And finally, this may be of some interest to those who are on the school board, school alliance, sorry. We did submit a modified letter to the ministry requesting some investigation to the Thames Valley School Board regarding the Rural Education Task Force and how it was handled. It was a modified letter that was prepared by Warden Warwick and signed by the 3 municipal representatives, Mayor Sally Martin from Central Elgin, Mayor Marcus Ryan from Zora, and myself.
Can you be more specific on what the letter What did it entail? Yeah.
It's, yeah, I can forward you a link to that if you wish. It was-
Forward the copy and then I think that's the best way is to.
Yeah,
Okay.
it was on the news, so there's a link.
Yeah, so I think the best, let's forward the letter just to, okay, if Adrian forwards that. And it was a very modified letter from what it was originally intended. So, okay. Anything else for the county?
Didn't you forward something about the representation for the next election? Was there something about that?
So that has just been made. That's been made official, correct? Go ahead.
So what you recall is the email I sent out earlier this week. So from the county of Middlesex, the county representation is determined from their bylaw and their thresholds. So the determining factor was, at the end of the day, confirmation that they're going to be using the 2018 certificate from the clerks on the number of electors at the end of the election. So last election in 2018, we fell below the threshold of 5,000. I believe we were around 4,869. So what that meant was for this upcoming term, 2022 to 26, that would leave one representative attending county council from North Middlesex.
So how many is there set on total right now?
11. Then, and there will be 10 next term.
Okay, who's the only ones that have the 2 representatives?
Middlesex Center, Strathroy, Caradoc, and Thames Center. Correct. Yeah. And it is something we discussed for quite a while, actually, right going into the last term when Southwest lost members. So, but that is the county allotment to the. So. Yeah. Okay. So reading of the bylaws.
So based on input from the CAO on the Merit subdivision advancement, there was another bylaw was needed in order to carry out the 2 agreements. So we are going to be naming that bylaw 45 of 2022, and that again is the severance development agreement with Merit Estates Inc. So we're looking for first and second reading on bylaws 40, 43, 44, and the newly added 45.
Councillor McClinchy and Councillor Hemming, all in favor?
And third and final reading will include bylaw 21, 40, 44, and 45.
Councillor Nickel, Councillor Moyer, all in favor? Carried. So we have a recommended motion that open meeting adjourned to closed meeting. And it is for under section 239E, litigation or potential litigation, including matters before administrative tribunals affecting the municipal or local board, potential tree claim in Park Hill, in the town of Park Hill. Motion to go into closed. Councillor Moyer, seconded by Councillor Hemming.